my ladies and my lords, we advance 5 points on this appeal. First of all is the argument that we have made the subject of our supplemental submissions. So one, the statutory framework of a compulsory treatment order, a community treatment order, does not create a deprivation of liberty.
Interesting slip you just made.
Well, it was a slip, but definitely not a telling slip, I hope. The second submission, alternatively, the principles articulated in Cheshire West should be modified in a case such as the present. We say consistent with the Strasbourg case law. And if those two arguments, or one of them, succeeds, the remainder of our submissions do not fall to be determined, but they do if either of those submissions fail. So point number 3, if and to the extent that the CTO framework does create a deprivation of liberty, the statutory power to create a deprivation of liberty does not have to be an express power, but may arise by necessary implication. My learned friend in argument this morning almost conceded that point, but sotto voce dropped in a sentence about still needing express words. So that is a point that needs to be nailed. Our fourth submission is on that footing, that's to say the necessary implication footing. The power to create any deprivation of liberty that there is necessarily to be implied into the CTO provisions of the Mental Health Act. And finally, we, on the jurisdiction arguments, suggest that the Mental Health Review Tribunal does not have jurisdiction to discharge the patient on the ground of an unlawful condition in a CTO, whether or not the condition creating a deprivation of liberty. The patient's remedy in that situation lies in judicial review. Now, starting with our first point, I don't blame Miss Richards any more than I blame the Court of Appeal, because we shared the same misapprehension in making a link between the conditions imposed under a CTO and a deprivation of liberty. However, having reflected on the matter, and that's why we formulated the new argument, we consider that that link is in error, and that the condition-making power under a CTO is incapable, legally, of creating a deprivation of liberty. Fundamentals.
Amazing that you should have taken so long for that penny to drop.
It's taken a long time, and it only finally dropped. I have to be candid with the court. It only finally dropped in its most precise articulation, which I'm about to articulate now, this morning. But the fact is that conditions under a CTO, the condition-making power, is separate from the need to comply with the conditions. The condition-making power is important because it lays down a framework by reference to which the patient's ability to cope in the community will be measured. If a patient does not comply with particular conditions, there is the possibility of recall. It may well be an incremental possibility, so one or more conditions may not be complied with for a time, but there will come probably a time where the order may break down and recall will be necessary, not as a sanction for failing to comply with conditions, but as the inevitable consequence of a breakdown of the therapeutic relationship that was intended to be created in the community. But fundamentally, the constituent elements of deprivation of liberty were laid down in the Stork case. I'll give you a reference rather than take you to it. The three constituent elements are stated in different paragraphs of Stork, but were, I think, now universally accepted. So it's Stork Volume 4, tab 40, MS 1826 at paragraph 74, and MS 1830 at paragraph 89. But the three elements of deprivation of liberty are, first of all, confinement in a limited space for
a not insignificant
not
time.
insignificant period of time. Second, consent.
You mean lack of consent?
I mean lack of consent, I do. And thirdly, state attributability. And so far, the argument has made the link between a condition, which is said in the words of my learned friend's reply this morning in paragraph 4, paragraph 5 rather, the respondent's assertion that CTO conditions are non-mandatory is not accepted if by this it's suggested there is no requirement on the patient to comply. Well, unlike a conditional discharge where there is a statutory requirement to comply with conditions, the answer to the non-mandatory nature of conditions under a CTO is in fact provided in the appellant's own case and in our response to it. So if I could invite you to look at the appellant's case at paragraph 30. These were the provisions that my Lady Hale was referring to this morning about them being complicated. And my learned friend said she might come back to them in reply. It's the consent to treatment provisions. So paragraph 30 of the appellant's case, where a patient is detained in hospital under the MHA, there is an express power under Part 4 to give, inverted commas, medical treatment, close inverted commas, against the plaintiff's consent. By contrast, under Part 4A, a patient in the community on a CTO cannot be given medical treatment without his consent or a best interest decision in the case of a person who lacks capacity to consent, see sections 64B and 64C. And then these important words with which we registered at the time our agreement. In this context, the term medical treatment has a very wide meaning and includes, quote, nursing, psychological intervention, and specialist mental health, habitation, rehabilitation, and care. And then this last sentence, which is the fallacy. Accordingly, any conditions of a CTO that purported to compel compliance with a specialist care regime, such as that to which PJ was subject, would be contrary to the express requirements of Part 4A. And then our response to that in our case at paragraph 30, paragraph 32, MS page 104, the appellant's case at paragraph 30 is misconceived. The appellant states correctly that a CTO patient cannot be given medical treatment without his or her consent, but that does not prohibit a condition in the CTO that the patient take medication. The same applies to treatment other than medication. And then perhaps the last missing link in all this is just to refer the court to section 145 of the Mental Health Act, which gives the wide definition of medical treatment. Now, one can go through the provisions 64A to K of the Mental Health Act, but they clarify that in relation to relevant medical treatment, a patient's consent, capacitous patient's consent, or if non-capacitous through a donee, is required for relevant medical treatment. And relevant medical treatment has the definition in section 145 by cross-reference. And so we respectfully suggest, without even going to the detail of the arguments that we put in our supplemental submissions, that it is nonsensical to speak of a deprivation of liberty against the statutory framework. It doesn't make sense to contend that a condition, because all conditions under a CTO are concerned with treatment, can coerce a patient to comply. Because the second element in STORK is required, namely consent. And the statute could not be clearer about that consent being required. Now, this means, the logic of this means, because we're not concerned with the facts in this case, my learned friend has placed some emphasis on the facts and the absconding protocols and so forth. What we're concerned about is that the law should be clarified, and we suggest that the clarification of that law makes the patient, ultimately, whether capacitous or non-capacitous, the judge of whether they are going to comply with conditions. It doesn't make sense to say that a condition can coerce. The condition can't coerce precisely because of the consent provisions in the Mental Health Act. And because it can't coerce, the problems identified by Mind, to a lesser extent by my learned friend Ms. Richards, of pressure building up, may be inevitable, but one can't conduct a subatomic forensic inquiry into below the statutory articulation of the need for consent in each of the cases.
Surely, as deprivation of liberty under Article 5 is judged in accordance with the concrete situation of the person concerned.
Yes.
And the concrete situation of PJ is that he is subject to the various management plans, and physical things will be done to him if he doesn't comply.
But that is contrary to the express provisions of the Mental Health Act.
Well, you've said that, but as I say, we're looking at the concrete situation of the patient.
Yes, but
What will happen if he tries to leave? Will he be prevented from leaving?
it would be
Or will he be able to say, you can't stop me, these are only conditions, there's no sanction for breach, you have got no power to lock me up?
the latter. That must be the logic of our submission.
It is the logic of your submission.
Yes.
Do you think that's a real submission?
Yes, it's a real submission once the law is clarified. The point is that until now, there has been quite a lot of ambiguity about the nature of the condition-making power, seen in the fallacy that we've all shared, that a condition itself can coerce.
But then what's the point in having these various elaborate plans if compliance is completely dependent upon his agreeing to it or submitting to it?
Because it's an attempt by the legislation, by the legislature, to provide a voluntary framework for reintegration into the community with the certain types of patient. Now, that reintegration isn't going to happen if the patient successively breaches the conditions of a CTO. But one can't bypass the statutory framework and say, well, the conditions are compulsory because on the ground people feel pressured. The Act makes it clear that they are not compulsory.
They're more than pressured, aren't they?
Well, my lady, the point is that when we get into the arguments about express words, for example, there could be no words more express than section 64A to D. Those are the express words of the statute. They say that conditions, they say that treatment cannot be administered, and treatment includes all the elements under a CTO, without a patient's consent.
It includes, does it, where he lives and
Yep.
that he's not allowed to go out?
Absolutely.
That includes treatment.
Absolutely.
So, I mean, sometimes this does happen with the statute, that suddenly everybody looks at it from a completely new angle. But isn't this going to change the use of CTOs completely, if you're right?
Yep, it may do. It may turn the common perception of CTOs on its head. I accept that. But the fact is, if one is conducting or undertaking a legal analysis of a CTO regime, you can't get below a statutory provision that says it is dependent upon consent. And that is what these provisions say. Now, it will make the patient the judge rather than the clinicians, and that may well, I accept that, my lady, that may well turn the common perception of what can be done under a CTO on its head. But that doesn't really matter when one is trying to analyse what the provisions actually mean.
There are responsibilities, aren't there, to give clear and full information to patients about what the situation is.
There are.
So if your argument succeeds. Well, it's obviously correct to a certain extent, but we're looking at the difference between the statutory framework and the reality. But your argument would require the clinician, when explaining to the patient what the conditions were, to have a great big banner headline at the top saying, but you don't have to do this. The only thing we can do if you don't do it is recall you to hospital.
That's correct. Yeah. And in fact, that's what, on one analysis, was done in this case, because PJ was apparently told that his conditions were non-mandatory. Now, my learned friend has put us a gloss.
What, in those words?
Well, according to Mr. Justice Charles's judgment at paragraph 31 in those words, so the reference for that is Appendix Part 1, MS page 216.
Well, of course, non-mandatory means two different things in this context. And do you suppose non-mandatory meant anything to PJ?
That's the point that I think Ms. Richards makes in her reply. But as she also says, it doesn't really matter for the purpose of analysis what PJ was told. What really matters is, what is the law? And if one just fast forwards for a moment to the other submissions in this case, the arguments that have been raised about express words, about protections and so forth, what express words could be used in a statute to say that conditions are non-mandatory when the Act contains 5 sections saying that, in effect, by saying that treatment under a CTO means relevant medical treatment, and a patient's consent is required, both whether they're capacitous or non-capacitous. And to our minds at the moment, it's very hard to conduct the argument any more widely on the other points in the case, the main points, when one bears in mind those statutory provisions. They are absolutely clear.
Have we got them? Have we got them?
Oh, yes. They're Authorities Volume 1, starting at MS page 518. So section 64A, in this part of this Act, and the heading, part 4A, is treatment of community patients not recalled to hospital. So it's definitely covering this case.
And this says means medical treatment. And
does.
your definition of medical treatment includes you will live here and not go out.
145,
Yeah,
which
thank you.
is at page, but it starts at page, MS page 557.
Got it.
But the relevant bits are at 559 to 560. So medical treatment, this is a point made by the appellant. Medical treatment includes nursing, psychological intervention, and specialist medical health, rehabilitation, and care. But see also subsection 4 below. Go to subsection 4. Any reference in this Act to medical treatment in relation to mental disorder shall be construed as a reference to medical treatment, the purpose of which is to alleviate or prevent a worsening of the disorder or one or more of its symptoms or manifestations. And of course, the criteria for the making of a community treatment order are all designed to that end.
Yes, but not being able to have a female supervisor or go out on his own and so on. It's stretching it a little bit to say that's for alleviating or preventing the worsening of the disorder. It's one of the other grounds is protection of other people, isn't it?
It is, but in a sense they merge, because if the consequence of a mental disorder is you're going to be a threat to other people, then care, and it is very widely defined, care must embrace that consideration too. If one just goes back to section 17A, which is at MS page 483, subsection 17A, subsection 5. These are the criteria for the making of a community treatment order. So the relevant criteria are A, the patient is suffering from mental disorder, etc., which makes it appropriate for him to receive medical treatment. So that's the defining criteria. B, it's necessary for his health or safety or for the protection of other persons that he should receive such treatment, so that's medical treatment for mental disorder. C, subject to his being liable to be recalled, such treatment can be provided without his continuing to be detained in a hospital. D, it's necessary that the responsible clinician should be able to exercise the power under section 17E1 below to recall the patient to hospital, and E, appropriate medical treatment is available to him. So we do submit with great respect that the Act is, and perhaps the court can see why it took us so long to catch this. It's not an easy concept to grasp. It's counterintuitive in a way to say, well, a condition can't impose a deprivation of liberty, but it can't under the regime. When you work out that the term deprivation of liberty has the three component elements in stalk. Consent is vital second element to a deprivation of liberty. But that doesn't mean that conditions can't embrace that which might be a deprivation of liberty if the patient did not consent. The conditions have to be tailored to what is necessary to ensure the patient's survival, if that's not too dramatic a word, in the community.
Well, can one stop at the consideration of consent and say that since consent is a prerequisite, there cannot ipso facto be deprivation of liberty? Or must one go beyond that stage and ask, what are the consequences of a withholding of consent?
The consequences of a withholding of consent under a CTO are as follows. First of all, if I'm right, the condition-making power of a CTO is not confined by questions of confinement. One makes the conditions which are necessary in the judgment of the responsible clinician to ensure the reintegration of the patient in the community. The patient then has a choice. It's unlikely that in practice a CTO would be made if there was wholesale reluctance to comply with any of the conditions. But consent can be given and it can be revoked. And the patient will have to have it explained to him or her that he or she has that choice. If there is a breach of one condition, it's unlikely to lead to recall, assuming that a CTO has been, in practice, thought capable of being made. There may be 2 or 3 breaches, but at some stage, a recall to hospital, if the arrangement breaks down, is likely. But it doesn't invalidate either the CTO regime or the attempt to persuade the patient to comply with the care plan.
But must one not examine, as my lady has put it, in terms of practical reality, what the consequences of failure to adhere to the conditions that have been imposed will be? In paragraph 20 of the appellant's case at 286, a number of factors are outlined which, it is suggested, demonstrate the practical reality of the deprivation of liberty here. It's all very well to say at a theoretical plane that consent is a prerequisite, but surely one must go further and ask whether, if the consequences of a withholding of consent will be the imposition of these restrictions, to use a neutral expression, that does amount to a deprivation of liberty.
I'm sorry, the recall power is a power to recall to hospital, but is not inexorably attached to a breach of conditions. So one can have a breach of conditions,
Yes.
which does not trigger recall. One may not have any breach of conditions, but recall can still occur. So recall is not dependent in any way, and this would have to be explained to the patient, on whether he or she consents, but it is a factor that may be taken into account in deciding whether to recall. And on the ground, because this is your Lordship's concern, I apprehend, on the ground, in practice, clinicians will try to give the CTO as much rope as it can bear. But if there is repeated breakdown of the arrangements, a recall is inevitable. But that is merely to acknowledge and to accept that, unhappily, that which was envisaged and hoped for has not worked. Whilst I think of this point also, my lady asked Miss Richards earlier in the day, well, isn't there one respect, at least, in which conditions outside on a CTO are better than hospital? That's where you can't force medical treatment. Well, the answer is you can't force medical treatment on a CTO at all. So inevitably, the conditions under a CTO are greatly improved from those in compulsory detention in hospital.
Can I just take you to 17b, though, which is the condition provision, which I don't think we were looking at when you were first outlining this point. We started at 17a, didn't we? It's
Yes.
486.
Yes.
And when you read that, it seems to have a community treatment order which has an existence, and then it has conditions to which the patient is subject whilst it is in existence.
Yes.
But then if you look at them, A and in 2, these are the may specify conditions. So these are the non-obligatory, in statutory terms, conditions.
Yes.
And the first one is receiving medical treatment, which has the wide meaning that you say,
Yes.
but the others don't have that.
No, but they, as we say in our case, I think it goes back to the criteria for making of the order. So all the criteria relate in 17a to criteria relating to medical treatment. Medical treatment, as I said earlier...
That's the threshold. The relevant criteria are the threshold, and then the orders that the conditions that can be part of the order are in 17b2, and they're not all relating to medical treatment.
Well, I tried to give your ladyship a connection earlier, and that's the best I can do, but preventing risk of harm to the patient's health or safety, that's a condition which justifies compulsory medical treatment in hospital. Safety, one may apprehend, is connected to the mental disorder, as is protecting other persons. So all those criteria merge in practice and would require, under our analysis, consent. And if this is correct, and it's such a fundamental point that...
It's very fundamental.
It's very fundamental, but in my respectful submission, it is correct, legally correct. And indeed, any other analysis makes it extremely difficult to apply a regime of this kind, because the regime is clearly designed to test out a patient's ability to become integrated in the community. It may require any amount of conditions which have to be consented to be effective. But the criteria are, first of all, effectiveness for the condition-making power, and then you come into the separate rock, and that may, if complied with, create the first condition for deprivation of liberty. But it's precisely because it does not have to be complied with under the Act itself, under the express words of the Act, which makes a community treatment order both lawful and coherent. Where it is surprising, and I accept my lady's point on this, is it will change the conventional perception. But that is irrelevant.
It will also change actual practice.
It will.
Not the conventional perception, but actual practice.
It will.
It will make the sort of conditions that were imposed in this case, in practice, impossible.
Yeah, I accept that. On the other hand...
Presumably you have instructions to
Yes.
make this argument.
Yes. My learned friend's argument would also make the regime impossible in practice for reasons I'll come to later. But that is the argument. And in our note, in our supplemental submissions, we skirt round this in a way that I haven't just now skirted around it, but we do it by reference to the statutory history. And in paragraph 5, we set out the difference between the community treatment order provisions and the former supervised discharge. The differences between the two regimes are summarised at paragraph 7, so you have a wider condition-making power under a CTO. But if I'm right that the condition-making power itself cannot be coercive legally, then the wider condition-making power makes little difference. The recall power in relation to a CTO, but again, my Lord talked earlier of the threat of a recall to restrictions. The same threat existed under supervised discharge, because if the supervised discharge arrangements broke down, there would simply be a resectioning under Section 3, and the patient would have to be aware of that. So the recall power is, if one likes to put it in this way, a more defined power. But if a supervised discharge arrangement broke down, there would simply be another application to resection the patient. So any element of compulsion, any supposed element of compulsion existed under supervised discharge. And so that is essentially our first submission.
Could I just ask, Mr. Gordon, and you may not want to answer this question or you may not have an answer to this question, but it's obviously of very considerable importance, not only to the Welsh Ministers, but also to the Department of Health.
Yes.
Which has responsibility for the operation of this legislation in England. Have they been consulted about this?
Not by us.
It's your argument, and it will have huge implications for them.
Well, we haven't consulted them, partly because this way of formulating the argument has only recently occurred to me. But it hit me with such force.
Well, it may have hit you with such force, but I feel fairly sure that it will hit the Department of Health with even greater force.
My lady, I wasn't trying to compare the force field effect, simply to say that's why we haven't consulted them. It's a late development in our thinking.
Yeah.
And I think the court can understand perhaps why it's been quite hard to reach this level of analysis.
And, it's never too late to have such thoughts. I quite appreciate that. But from our point of view, were we to even begin to consider this argument, we would want to know what the Department of Health thought of it. And we'd also, for that matter, want to know what the Secretary of State for Justice thinks of it, because there are obviously knock-on effects to the other case.
Yes.
The case.
Yes. Although in the case, the difference between that and this is that Section 73, I think it's subsection 4, imposes a statutory requirement to comply with conditions. So there is the element of compulsion.
Well, except that it's an unenforceable statutory requirement.
But, my lady, we take the court's thinking on this, and certainly that can be done.
Well, it had probably better be done before we reach any final conclusions about this, or at least certainly go public on what our final conclusions are.
Yes.
It's a different matter. If the Department of Health comes back and says, oh, yes, we think that's a very good idea, completely destroy the effectiveness of community treatment orders in most cases.
Well, whether they think it's a good idea or not, it has to be squared with the provisions of Section 64A to D.
Yeah, I understand.
The problem is also that once one goes along this line of thinking, it becomes very difficult to isolate the remainder of the argument on compulsion. One has to. It's not just that theoretically there may be a deprivation of liberty or there may not be. It's what is the kind of deprivation of liberty. Because this is leading on to my next point, but this is not the paradigm case of a deprivation of liberty that places a person in a confined space against their will by state action. It is, at most, in making this submission, I don't minimize its importance for the patient, but it's at most compulsion that stems from the patient's own mind, internal state of perception, rather than objective, in which case It's quite hard to see how it goes to the objective component of deprivation of liberty, but it may go to the subjective component element.
Can I just ask you to what extent it is an obstacle in your argument that the definition in section 64A is in this part of this Act, and the condition provision is not in this part of this Act? Section 64A begins in this part of this Act.
Well, it's treatment of community patients not recalled to hospital. And so for the purpose of treating community patients not recalled to hospital.
Well, that's the heading of the section, but the condition section is not in that part.
No, but that's my point. The conditions can be made, they're quite separate from compliance with the conditions. So the condition-making power exists unaffected by the consent provisions. But when it comes to implementation of the conditions, complying with the conditions, then the consent provisions kick in. That's the whole point, that the separation of the broad condition-making power from any form of coercion. There is no coercion through a condition, is the simple point. So if the condition doesn't coerce, where is the coercive element necessary for a deprivation of liberty? One has to isolate that in order to conduct the rest of the argument, because when we get into express words, we have express words in the Act. When we get into necessary implication, we have express implication. When we get into remedy, in a way, it's not a conventional deprivation of liberty case. And so this argument doesn't only cohere in its own right, but it affects the whole of the rest of the analysis. One has to isolate where is the coercion.
Well, you say that the coercion may inform the subjective element of deprivation of liberty, in that an individual confronted with conditions could operate in his own mind the deduction that if he failed to comply with them, that he would be subject to recall. Is that necessarily an exclusively subjective issue? I'm not saying that it could be shown to be the case, but if it were the case, for instance, that there was widespread recall of patients who failed to comply with conditions, would that not also sound on the objective element of deprivation of liberty?
I don't think so. It's a question of understanding the analysis in the light of all the provisions of the Mental Health Act.
Well, let me put it this way. If it was well known that a failure to comply with conditions would bring about recall, would a reasonable person, not considering that circumstance, not conclude that it was likely that they would be recalled if they didn't comply with the conditions?
Well, that's not what the statute says. The statute says two things. First of all, it says the conditions, insofar as they affect medical treatment, relevant medical treatment, require consent. And secondly, it says that the recall power is not triggered by a breach of conditions. So the statute could not be clearer in its intended effect. What operates outside that on any individual set of facts may affect whether consent was validly given, but that can't affect the legal analysis in our respectful submission. Because there's nothing else the Act could say other than it's got to have a recall power, because if a community treatment arrangement breaks down, there needs to be a recall power. And if there are successive breaches of conditions, it's likely that will be taken into account in determining that. But if one's going to have any kind of regime which is not designed to create deprivation of liberty of itself, what you'd expect to see is A, a provision stating that the recall power is not mandatory on breach of condition, you have it, and B, that treatment under the community treatment order is not compulsory, and B, you have it as well. So it's hard to see how the statute could be or could have been any clearer But I do appreciate, practically on the ground, the effect this will or may have.
No.
So hopefully the court can see why we thought it necessary to put this argument right at the start. And that is my first submission. Our second submission is that the Cheshire West principles should be modified in a case such as the present. And it isn't quite as simple as it may have appeared to my learned friend Ms. Richards. This argument assumes, contrary to our point one, some form of compulsory element to the CTO regime, but maintains on that assumed basis a restriction on movement rather than a deprivation of liberty. And the reason for making that submission, which is a submission we made below, is that it focuses on the nature, purpose, and general approach of the Strasbourg Court in cases relating to deprivation of liberty. It is true, as Ms. Richards has said, that cases involving deprivation of liberty have an autonomous meaning. But equally, it is true that in articulating that autonomous meaning, Strasbourg looks at context. And it's set out in the judgment of the Court of Appeal in the case of Jolla. I didn't mention Jolla, by the way, in my earlier submissions. It is a relevant case because that is a case on false imprisonment, but nonetheless talks about constructive imprisonment. And we differentiate that case from this because in Jolla, there were criminal sanctions for breach of conditions, which had to be complied with. But the reason I mention Jolla now, and it's in the supplementary MS pages 70 to 71, Authorities, Volume 5, tab 59. At paragraph 30, referring to the approach of Strasbourg, the Court of Appeal say this, and I quote from paragraph 30. In Article 5.1 cases, this is the approach of the Strasbourg Court as interpreted by the English Court of Appeal. In Article 5.1 cases, the courts tend to look at the restraint in question in the context of the whole picture, and a distinction between deprivation of liberty on the one hand and restriction on movement on the other is maintained. And then these words, which we submit are important, involving an assessment of the whole range of factors present, including nature, duration, and effects of the restraint, the manner of implementation and execution, and so on. And in the same paragraph, the court goes on...
Well, those words come straight out of Ghazadi.
As your ladyship said in Cheshire, will be repeated ad infinitum in Strasbourg, yes. But the court goes on in the same paragraph to consider cases in which, consistent with the Strasbourg approach, even very extensive curfew requirements or lengthy control order scenarios would not necessarily constitute a deprivation of liberty. The same contextual approach was adopted in Austin, and we've cited the various paragraphs of Austin, paragraph 76 of our case, so I'm not going to repeat them, but there are 5 relevant paragraphs illustrative of the proposition that the Strasbourg Court will take account of the type and manner of implementation of the measure in question. This morning, my learned friend Ms. Richards stated quite correctly, as we had indeed conceded, that Austin was a case in which there was no justification that could be advanced under Article 5 because it wasn't an Article 5 a typical scenario. But the same approach is adopted even where something is within Article 5, as we see from the case of Munjaz against the United Kingdom, supplementary MS, page 107, Authorities, Volume 5, tab 61.
Well, that was the lengthy seclusion case, wasn't it?
It was. And first of all, it relies on the reasoning in Austin. See paragraph 66, first of all, at MS page 135. Indeed, as the Grand Chamber has recently reaffirmed, see Austin, and then the usual litany of matters. And also...
yes, and that's where I got the words concrete situation from.
Yeah, absolutely. I'm going to come back to concrete situation because the court's approach in Cheshire is a particular type of concrete situation. We say this is another. And then 69 to 72, we suggest adopted a highly contextual approach in those paragraphs on the concrete situation. So looking, for example, at paragraph 69, page 135, MS 135, first, in considering the applicant's concrete situation, the court considers some weight must be attached to the fact that at the time of his seclusion, the applicant was and remains a long-term patient in a high-security hospital. Translation here, at the time of the making of a CTO, this is Lord Wilson's The Elephant in the Room, the patient was under conditions of compulsory detention in hospital. Paragraph 70, second, it's clear that seclusion, though coercive, was not imposed on the applicant as a punishment. See translation, the threat of recall in the present situation. 71, and this is highly contextual, third, while the duration of the applicant's seclusion, particularly the 3 later periods, where he was secluded for 18, 14, and 9 days respectively, would point towards a further deprivation of liberty, the court considers this alone is not determinative of the question. The length of the applicant's seclusion is foremost a matter of clinical judgment. Seclusion could only continue for as long as those responsible for the applicant's care judged it's necessary. Finally, of greatest weight, this is paragraph 72, to the court's conclusion that there has been no further deprivation of liberty in the applicant's case is the manner in which his seclusion was implemented. The court accepts Ashworth's evidence, etc. So what we say is that Cheshire West was a case with a particular concrete situation of highly vulnerable people. But the patients in this category of case are equally vulnerable. But it works the other way. The concrete situation, we suggest, works the other way. To classify conditions under the CTO regime as a deprivation of liberty has the effect, unless that deprivation is lawful under the regime, of removing the opportunity to benefit from a CTO for those in the most vulnerable position. My learned friend said today, well, there's no evidence of that. It's not an evidential question. It's clear that the Cheshire West threshold of constant monitoring and control is a fine judgment set of criteria which could easily be bypassed in a vulnerable patient under a CTO.
The circumstances in one of the two, the non-contentious in Cheshire West case, the concrete situation of P in that case was virtually identical to the concrete situation of PJ in this case.
Yep. But the context is different.
Well,
and the context is well, that's the question. I mean, I accept that that's the question, but we say the context is different because the purpose of this statutory regime, maybe not immediately, but the purpose of this statutory regime is to enhance liberty. It's actually a staging of release, discharge of the patient from hospital. And it's that concrete situation, that context, which we submit the Strasbourg court would, applying the approach, the contextual approach it does.
Hadn't P been in hospital before he was discharged? In Cheshire West?
PJ?
No, P.
Oh, P, sorry.
He won't have been sectioned, probably, because he was so disabled. He was more disabled than
yes.
PJ. But I think you'll probably find that the setup was in the context of his having previously been in hospital.
But the purpose of deprivation of liberty under the MCA is not, doesn't have the same statutory purpose as a CTO. So the concrete situation has to embrace, we submit, respectfully submit, the statutory regime and its underlying purpose.
Does this, is an alternative formulation of this that it isn't deprivation of liberty because he's getting more?
That's putting it somewhat starkly, but yes, in a sense, the ultimate destination is one of enhancement of liberty. It's not an Ashworth Hospital type scenario where, under a Section 3 detention, removal to a place of lesser conditions of security still remains a deprivation of liberty. It's a different type of situation. It's a specific statutory regime designed to enhance liberty. So that's the alternative formulation of an argument that assumes against my first argument that there is a measure of compulsion under a CTO. It's a slightly artificial argument because our main argument is there isn't. And it's affected also, I would submit with great respect, by the inevitable rock that one comes across, whichever way, whichever argument one is considering, that one has the consent provisions. One can't just forget those. They're relevant to each and every argument here. And so whatever role one gives consent, it's there in the Act and forms part of the contextual background in our submission. So that's our point 2. Point 3 is an easier point in many ways because my learned friend did retreat from her position in her case that one had to have express words in a statute to justify deprivation of liberty. And we say that she was correct to retreat from that proposition and to rely on Sims, the material extract from which is in the speech of Lord Hoffman. It's cited in the appellant's case at paragraph 23, and it makes it clear that...
Well, what she said was that Lord Hoffman left open the possibility of necessary implication, but she said that this was not a case of necessary implication. And it was very difficult to imagine a situation where it would be. That's as I understood what she said.
Yes, but one can have necessary implication. That's our 4th point. And we say that all the authorities cited between paragraphs 15 to 21 of the appellant's case are all authority for the same proposition, namely that the law must be clear, not that it must be express. Nor does the argument based on specific authority take the appellant anywhere. This is Lord Justice Laws in Bancourt, because as soon as one starts to put under the microscope forensically the concept of specific authority, it collapses into a requirement of express words. If there is to be necessary implication as a separate concept, which we submit there is, it applies across the board, whether in cases of vulnerable mental patients or any other context of deprivation of liberty. And we say that Parliament has squarely confronted, to use the language of Sims, when it intends to override fundamental rights, because one has to look at the community treatment order provisions as a whole, and that is our next point, our point number 4. So we accept that one has to look at the language and logic of the statutory provision in question, but we say in resolving whether any supposed deprivation of liberty is created by a community treatment order, apart from the inevitable reminder that we have section 64A to D, which is in our submission squarely confronting, as far as it can be squarely confronted, the problem of a deprivation of liberty. But there are 3 real questions to answer in the context of necessary implication. The first is the parliamentary intention clear? And could that intention be achieved without the possibility of conditions which might, in theory, cross the Cheshire West threshold for deprivation of liberty? The second question is, are the criteria for the making of a CTO sufficiently clearly expressed to cater for a deprivation of liberty in that sense. That's the Cheshire West sense. And that raises the issue of prescribed by law under Article 5. And the third question is, are there adequate safeguards to allow for the challenging of unreasonable conditions in a CTO? And our respectful submission is, if those are the three relevant questions on necessary implication, each of them should be answered in the affirmative. Dealing first with, may a deprivation of liberty be necessary to achieve the parliamentary intention? The Court of Appeal summarised, we say correctly, the statutory purpose of the CTO regime at paragraph 53 of its judgment, MS page 200, core volume, appendix part 2. And it was, and I quote, to achieve integration of a patient into the community with the minimum interference with the patient's freedom of movement, commensurate with the protection of the patient and the public. And we submit that that statement of purpose is the same, materially the same, as the purpose advanced by the appellant in their case at paragraph 39. And there can in any event be no doubt about the statutory purpose of underpinning CTOs in the words of the interim review of the Mental Health Act report, which is to be found, it's in May 2018, to be found in Authorities Volume 4, tab 54, MS page 1987, at paragraph 7.11. CTOs were introduced in the 2007 amendments to the MHA as a kind of supervised community treatment for people who've been detained under Section 3 and certain other sections of the MHA in order to allow suitable service users to be safely treated in the community rather than in hospital. So that's the acknowledged statutory purpose. And the only difference we can detect between the appellant's treatment of the statutory purpose and that of the Court of Appeal is the assertion made by the appellant in the case at paragraph 40 that the statutory purpose, quote, can be achieved by a full range of measures but falls short of depriving a patient of their liberty. Now, earlier on, my learned friend castigated us for not providing evidence, but as I said earlier, it's not an evidential question. But here, the assertion is that a full range of measures can fall short of a theoretical deprivation of liberty, an assumed deprivation of liberty at this stage of the argument. And there are 2 points to make about that. First, the framework required, self-evidently the framework required for conditions under a CTO will vary between patients. So a responsible clinician is therefore given flexibility to set the conditions with the agreement of the approved mental health professional. It follows, we say, that the appellant is incorrect to suggest that the statutory purpose can necessarily be met, the word here being necessarily be met, by conditions falling short of an assumed deprivation of liberty. The appellant's suggestion would impose an arbitrary restriction on the power of the responsible clinician and AMHP to decide on the facts of each case whether the required treatment can be provided without the patient continuing to be detained in hospital, and what conditions are necessary or appropriate for the specified purposes. That power is deliberately broad because it's designed to cater for a myriad of patients. Many cases of CTOs will not involve, perhaps most cases, will not involve deprivation of liberty. And if there is an assumed deprivation of liberty, contrary to my main point, in the case of a few patients, that is necessary for maximum flexibility to achieve the purposes of the CTO regime. So that's our first answer to the appellant's point. And secondly, at paragraph 40, the appellant does not rule out that, quote, the power to impose conditions so restrictive as to deprive patients of their liberty might in some cases be desirable. But we say in the context of this statutory regime, that is a concession that such conditions are indeed necessary. Because if the responsible clinician thinks this is a desirable condition to impose having regard to this type of patient, having regard to the statutory purposes of the CTO, it is a necessary condition. Now, in its intervention, Mind gives a number of policy reasons for disagreeing with the CTO regime, and we respect those policy differences, but they're not a legal answer. And Mind's points come down, we say, to a critique, to a disagreement with that policy. But in fact, none of their objections work either. So first of all, paragraph 32.1 of its case, Mind says that a patient who agrees to the care plan on discharge should simply be discharged. But we respectfully submit the facts of the present case demonstrate how the legal framework of the CTO provided important reinforcement which assisted the appellant. We can see that from core volume, page 251, paragraph 4.10 of the tribunal decision. Really the last sentence of that paragraph, the legal framework of a CTO is said by the team to be a reinforcement, repetition being as important to the applicant as boundaries, which assist the applicant to feel safe. The tribunal accepts as a need because the appellant's historic nature of illness and current uncertainties based on the risks that have been evident and the need for treatment through ongoing therapy structure and support. The CTO is a framework which can also enable monitoring, review and recommendations. The tribunal believes this must take precedent over any human rights issue, perhaps a unfortunate phraseology. But the fact remains, you can see what the tribunal is getting at in the context of the CTO there. Secondly, Mind says, see paragraph 32.2, that where a patient has relevant capacity and does not agree to the conditions or care plan, then a CTO with conditions is likely to be ineffective. But in this case, the appellant was generally happy under the CTO, but wanted greater freedom to see his family and girlfriend without restriction. In this case, the CTO was effective in that it resulted in the appellant's safe treatment in the community and his eventual discharge altogether. The appellant had spent most of his adult life in hospital with a forensic history dating back to 1986. See paragraph 22 of the judgment of the upper tribunal. Perhaps just go to that very briefly. So it's core volume, page 214. It's really, yes, paragraph 22, spent most of his adult life in hospital with forensic history dating back to 1986. In 1999, when he received an unrestricted hospital order for ABH and threats to kill him, was in a medium secure unit, and so forth. So this is a case of a successful CTO. Thirdly and finally, Mind says that Section 17 leave should be used instead. They say that at paragraph 32.3 to 32.4, because that's the appropriate provision for testing out readiness to be treated in the community. But as we said in our case, the CTO provides an opportunity to test life in the community, but that is merely one possible effect. Furthermore, under Section 17.2a, perhaps just look at that briefly. So it's Authority Volume 1. I think it's 17.2a. 480, I'm told, thank you. Yes, longer term leave may not be granted to a patient unless the responsible clinician first considers whether the patient should be dealt with under Section 17a instead. And so one has to consider first whether a CTO should be made before considering longer term leave under Section 17. That's built into the Act itself. So if our analysis under this first question of necessary implication is correct, it means that the appellant accepts the statutory purpose for which we contend, but contests what we say is the necessary implication of that statutory purpose in possible cases where conditions under a CTO may create a highly intensive framework. so as to provide the requisite circumstances to allow the patient to avoid having to be compulsorily detained in hospital with compulsory treatment, which is not compulsory under a CTO. Without the possibility of building into the CTO a highly intensive framework in at least some cases, with the type of deprivation of liberty envisaged for the purposes of this argument under a CTO, we say that the entire purpose of the CTO regime would be frustrated or subverted. Patients would not be released under a CTO, and they would remain detained in hospital for longer, perhaps never achieving release into the community. If that's the pressure which constitutes the deprivation of liberty, either it isn't a deprivation of liberty under our second argument, or it's a necessary deprivation of liberty to achieve the statutory purpose. If, of course, it is a deprivation of liberty, because you go back to those consent provisions. So, and when one looks at the criteria, we see this at paragraph 20 of our case. We set out with amendments, underlinings, and so forth, the similarity between conditions for admission to a hospital under a Section 3 with the criteria for 17A. And one sees it fairly graphically, hopefully, in that set of provisions. So the criteria are: he is suffering from mental disorder of a nature or degree which makes it appropriate for him to receive medical treatment, not in a hospital, but medical treatment. And that is the huge difference between the compulsory provisions and the consent provisions. Secondly, it's necessary for the safety or health of the patient or for the protection of other persons that he should receive such treatment. And then the words, and it cannot be provided unless he's detained under this section, deleted. Thirdly, subject to his being liable to be recalled, as mentioned in paragraph D below, such treatment can be provided without his continuing to be detained in hospital. And finally, materially, it's necessary that the responsible clinician should be able to exercise the power of recall. So there's a mirroring, this is again the elephant in the room, there's a mirroring between the two statuses with the mutatis mutandis amendments for community treatment order. But it's a staged process. Under compulsory detention in hospital, the patient has to submit to treatment. At the time of the making of a CTO, there has to be a Section 3 compulsory detention. And then the next stage, before release into the community, finally, is this CTO regime. And the close association with Section 3 is quite important in understanding the context in which this power arises. So there are a lot of other detailed points of interpretation raised by the appellant, which I'm not going to deal with because of time. Some of them deal with the overlap with the MCA. We've dealt with that in our case. Some of them deal with the different provisions of the code. My learned friend says correctly that you can't rely on the code as a useful aid to interpretation, especially when the English and Welsh codes differ. But essentially, that is, or those are the points we make. Ministerial statements, the same thing. None of the ministerial statements address the real issue here. So we say that the crux of the first question is, on the agreed statutory purpose and on the self-evident truth that one cannot achieve the statutory purpose without the assumed deprivation of liberty that we assume for the purpose of this argument. The statutory intention could not be clearer, and the statutory wording follows from that intention, including the consent provisions in section 64A to D. So the next question on necessary implication is, are the CTO provisions sufficiently clearly expressed? And that comes down to the Article 5 question, is it a procedure prescribed by law? And we say that it is. Once again, it's highly material that a CTO is attached to a Section 3 detention. The patient has been deprived of liberty under Section 3, is being moved to greater freedom under a clear procedure with a challenge to CTO conditions possible by way of judicial review. The phrase prescribed by law was considered by the European Court of Human Rights in Winterwerp, and I'm not going to go through Winterwerp in detail. I learned from the live stream that this court had considered Winterwerp in the MM case, and that your ladyship had commented, actually, that the criteria in Winterwerp, substantively at least, were very general.
Yeah.
Exactly. So this is relevant to the point I want to make about the Strasbourg need for clarity. Procedure is not in any sense arbitrary. There is an identifiable, well, the words in Winterwerp, and I'll read them if I may, they come from our case at paragraph 46, paragraph 45 of Winterwerp. The notion underlying the term in question is one of fair and proper procedure, namely that any measure depriving a person of his liberty should issue from and be executed by an appropriate authority and should not be arbitrary. So that's the Winterwerp, that's the guts of Winterwerp. And as I think your ladyship said, it's largely procedural. But the procedure here, we say, is fully complied with. First of all, there is not a lack of arbitrariness in the carefully crafted CTO regime. It is indeed a procedure prescribed by law in the Winterwerp sense, in that, first of all, there is an identifiable appropriate authority recognized in domestic law responsible for issuing the CTO. That's the responsible clinician. Secondly, as to the making of a CTO, see section 17A1 to 2, a CTO has to be in writing. It can only be made in respect of a person already and currently liable to be detained in hospital for medical treatment for mental disorder. That's the Winterwerp criteria. There are strict criteria relating to the need for treatment that must be met not only in the opinion of the responsible clinician, but also of the assistant AMHP in writing before the CTO can be made. The condition-making power is limited to ensuring the patient receives medical treatment and preventing risks to the patient and third parties. There's a power of variation and suspension. So it's not an arbitrary procedure in the Winterwerp sense, which itself focuses on procedural concerns. And as to temporal provisions, another important procedural guarantee, it can only be made for a limited time. See section 20A, renewed. And its legality has to be the existence of the criteria at each stage, that's to say initial making and renewal, is scrutinized by a mental health review tribunal. And the remaining provisions relevant to a clear and non-arbitrary procedure prescribed by law are those in section 17D to G. They address respectively the legal effect of a CTO, the powers of recall and revocation, the effect of revocation, and re-examination and review of the criteria and provision for extension. Quite apart from those provisions, as I've said, there's also recourse to a tribunal. And so for these reasons, we suggest, respectfully, that the requirements of Article 5 are met, prescribed by law. The Strasbourg Court requires the law to be clear, but it does not require express words to found provision, authority, for a deprivation of liberty. Now, at paragraph 49 of their case, the appellants set out a list of criteria that are suggested to be the minimum necessary for a law creating deprivation of liberty to be sufficiently clear. But they're made up. They're not the criteria laid down by the Strasbourg Court. And the case that is cited by the appellant in this respect is important because they cite HL. But far from presenting an obstacle to our case, HL supports our case. And perhaps one can I can refer you to it without turning it up and read it, but paragraph 120 of HL, MS page 1741, Authorities Volume 4, tab 37. I'll just read it. In particular, and most obviously, the court notes, this is under necessity, the lack of any formalized admission procedures which indicate who can propose admission, for what reasons, and on the basis of what kind of medical and other assessments and conclusions. There is no requirement to fix the exact purpose of admission, for example, for assessment or for treatment, and consistently no limits in terms of time, treatment, or care attached to that admission, nor is there any specific provision requiring a continual clinical assessment of the persistence of a disorder warranting detention. Now here, by contrast, if one takes HL as the paradigm case for procedural safeguards, what HL was criticising was the common law doctrine of necessity with absolutely no guarantees whatever and no formalised procedure. But here, by contrast, there is the equivalent of a formalised admission procedure in that there's a formal process for a CTO and conditions being made. The statute states who proposes the making of a CTO and for what reasons, and on the basis of conclusions as to the existence of the carefully defined statutory criteria. Once it's clinically assessed that a CTO is no longer necessary, it's required to be discharged, and with that discharge goes the authority for detention. See section 23(1)(a). So, quite apart from the point that I've made earlier, that this, on any view, is not a paradigm deprivation of liberty, the fact is that the procedure laid down in section 17 fulfills all the criteria required for prescribed by law. True it is that there is no express provision for deprivation of liberty contained in the condition-making power, but there's nothing to suggest that Parliament intended the condition-making power to be subject to a threshold above which conditions in accordance with section 17b are impermissible. So I've now answered, hopefully, two questions. Is it consistent with Parliament's intention? Is it a procedure prescribed by law? And then the last question, are there adequate safeguards? We say that the availability of judicial review to a patient to challenge CTO conditions complies with Article 5.4. As the appellant recognises, Your Ladyship on the application of H against the Secretary of State for Health stated that judicial review and or habeas corpus may be one way of securing compliance with the patient's Article 5.4 rights. And that is, we say, consistent with the Strasbourg Court's decision in the same case, MH in the UK, which is to be found at Authorities Volume 4, Tab 38, MS page 1751. See in particular paragraph 74 to 77. The European Court cited and did not disagree with what Your Ladyship had stated in that case, although it wasn't necessary for it to explore the matter in any detail. But that was a case where there was a tribunal route, and the court held that where the scheme makes a tribunal application the natural and obvious way of taking Article 5.4 proceedings, the Convention doesn't oblige a patient to attempt all conceivable remedies after unsuccessfully attempting the obvious remedy at their disposal. It's not relevant to this appeal because there isn't that issue. But since what MH did decide was that there needed to be provision for vulnerable patients to have access to a court, and since the events in MH, in Strasbourg and in the UK, additional protections have been introduced by amendment to the Mental Health Act 1983 through the 2007 Act to introduce provisions on independent mental health advocates. The local authority has a duty to make arrangements to enable independent mental health advocates to be available to help patients subject to the 1983 Act. See section 130A at supplemental MS page 12, Authorities Volume 5, tab 56. The definition of qualifying patients in section 130C2 applies to both patients liable to be detained and to community patients, and the arrangements should include, see sections 130B1 and 2, help in obtaining information about and understanding any rights which might be exercised under the Act, which would include access to courts, help by representation, or otherwise in exercising those rights. There's also a duty, see section 130D of the 1983 Act, Authorities Volume 5, tab 56, supplementary MS page 16, for a specified person to take such steps as are practicable to ensure that a patient understands the help that is available to them from an IMHA and how to obtain that help. there are equivalent provisions for Wales. So all these provisions introduced since the MH case make judicial review a practicable remedy. And not only that, of course, part of the help and assistance which of the most vulnerable patients, including patients who are not so vulnerable, would be required to be given would be information about their rights, information about the fact that there is no compulsion of their right under conditions under a CTO.
Mr. Gordon, if there can be deprivations of liberty in a condition attached to a CTO, then obviously there's got to be safeguards. We've got Section 72 here, the power of the tribunal to discharge a patient who is a community patient. We've also got a duty to be energetic under Section 3 of the Human Rights Act, to construe legislation in a way that enables us to comply with our Human Rights Act duties. And so apparently the suggestion was made by Mr. Justice Charles, well, in fact, before a tribunal discharged, if a tribunal was worried about a deprivation of liberty, he could adjourn and express his concern, and there would be dialogue with the responsible clinician. Equally, and this is only a variant on a theme, I think I suggested this morning, you could actually attach a condition to a discharge order or a refusal to a discharge order, which dealt with concern about a deprivation of liberty. Why are you so unenthusiastic about giving the Mental Health Review Tribunal these powers?
I'm not unenthusiastic, my lord. If it can be done, it would be a possible answer to the whole complaint, because if there is a deprivation of liberty, there do need to be adequate safeguards. The slight problem we detect, I haven't got to jurisdiction yet, but the slight problem that we detect is that conditions can be changed under a CTO, can be varied, and you couldn't go to a tribunal more than once between the period of creating the order and creating another order. So in other words, if the condition changed during the course of a CTO, there's no provision in the Act for recourse to a tribunal. Whereas
But if the tribunal had adjourned its hearing, there'd be no problem about that.
not in the case where the tribunal was considering a condition that was hypothetically contrary to, was a deprivation of liberty.
Yes.
But what happens if the condition changes after the tribunal's heard the matter into a hypothetical deprivation of liberty? There's no statutory route to a tribunal if that happens, but there is judicial review. So it's not that we're not enthusiastic about it. If it solved the problem, we would be only too enthusiastic, but we're not sure it solves any difficulties. But we say that, first of all, the burden would be on, the suggestion is made that in judicial review, the patient would have to establish the case. The burden would be on the patient. If there is a deprivation of liberty, the burden is on the state to justify it. So that it simply is not a correct analysis. Nor is there any unlawful discrimination.
So what is one challenging by judicial review? Is one going to the High Court to say, I have been deprived of my liberty, there is no power to deprive me of my liberty? Or is one going to the High Court to say, I have been deprived of my liberty, I should not have been deprived of my liberty? Or is one going to the High Court, and as part of that, would one be saying, well, the conditions imposed which did deprive me of my liberty were irrational? What's the question on judicial review?
The point, my lady, is this, that under judicial review, you can have a number of questions, and you can answer them in different ways at different thresholds of review. But
we need to know, for the purpose of knowing what can be put on a CTO, what exactly the question would be. Now, at the moment, of course, all the tribunal can do is discharge or not discharge.
Exactly.
And that's inadequate, really, to deal with the situation. But I'm wondering whether judicial review is any more adequate.
Well, judicial review, as we stated in our case, is more widely focused. First of all, it can actually engage in a high threshold of intensity of review with a human rights deprivation of liberty case in a way that we know the tribunal can't.
The tribunal can on any question within its jurisdiction. It's much better than
Exactly,
than judicial review, because it's actually looking at the merits of a decision.
but it can't in this context. You'd have to stretch the. What you'd have to do is read into the tribunal a power to review conditions.
Oh, at the moment we can't do that.
Exactly.
But I'm still trying to get my head round what a High Court judge will be doing in this situation, because the High Court judge can't investigate the merits
Well,
of the conditions.
in
They
a-
can
in a-
only
in a-
investigate the legality or rationality of what's being
the
done.
High Court can investigate the proportionality of a condition because it's a Strasbourg human rights point where proportionality lies as a ground of challenge.
Well,
And it could do that, although we have Lord Steyn and Daly saying it's not quite merits review, it's as close to merits review as you
actually,
get.
that wouldn't have to be judicial review. That could be a freestanding action under Section 7, couldn't it?
Could be either Section 7 or could be judicial review. But either way, there is an objective inquiry into the proportionality of a condition, and a remedy needs to be devised to meet that. So we certainly say that in this context, judicial review can do more than the tribunal. If the tribunal had all these powers, we would be, to use my Lord Wilson's words, enthusiastic. The only reason we're not is we think that judicial review is actually a more widely faceted remedy in this kind of case.
What are you reviewing, the CTO or the condition?
It would depend. It might be a CTO which had been made for improper reasons, perhaps, but if it might be a series of conditions. It might, the attraction of JR, the advantage of JR is that it might be one condition to which the patient objected in a meaningful sense, leaving the rest of the CTO intact. But the point is that the tribunal only has the power to discharge or nothing.
I've got that bit, yes.
So that's why judicial review is so much more, or perhaps an action under the Human Rights Act, Section 7,
Or
but
habeas corpus?
possibly habeas corpus, yes, in an appropriate case. Of course, it may not be the CTO that the patient wants lifted. It may just be a particular condition. And it may not
Habeas
even...
corpus would be a more confined remedy, of course, wouldn't it?
I'm sorry, my lord?
Habeas corpus would be a more confined remedy
Yes,
because it goes to the legality of the detention,
it would.
whereas you appear to be accepting that either under an Article 7 action or under judicial review, it would be for the maker of the CTO or the imposer of the conditions to show that they were not disproportionate.
Yes.
In the sense that you would have to justify the interference with the Article 8 right.
Yes.
Are we
the
talking
point
about
also-
Article 8 rights here, aren't we?
Yeah.
We're not talking about Article 5, because
No.
proportionality doesn't come into that.
No.
But the point is that the tribunal, a judicial review court could look at the situation from any of the several possible perspectives, including conditions that were objected to on grounds of proportionality, on Article 8 grounds. In other words, grounds...
As my lady points out, you'd have to follow the Article 8 route in order to get to the destination of proportionality, because proportionality doesn't arise in relation to
No.
Article 5.
No, that's true. But there could well be an Article 8 issue on a particular type of condition. So what we say is that the court system has sufficient remedies, whether by way of judicial review, habeas corpus, or a Section 7, depending on the complaint, which, unfortunately, the tribunal simply doesn't possess on any, however generous reading of the statutory provisions. And provided, we say, the patient is informed of his or her rights, as the statute now requires, these are adequate remedies, sufficiently adequate remedies to cater for the wider range of possible complaints that can arise under a CTO than anything else. And that's why there isn't discrimination here, because they're different scenarios, a completely different statutory purpose. We don't understand Mine's complaint that patients under the MCA have a different route, because the correct comparator here is between any patient subject to a CTO, including a capacitous patient. So the MCA doesn't really come into that comparison. which does really bring me to jurisdiction, and in a sense, well, I just make my 5 points on jurisdiction in relation to the tribunal's jurisdiction or lack of it. First of all, under Section 72 of the Mental Health Act, the tribunal only has a power to discharge. That's the point I've just been making, really. Secondly, that power to discharge is discharge of the patient, not the CTO. See the Court of Appeal judgment at paragraph 55. There is no provision for the tribunal to discharge the CTO, but leave a Section 3 detention in place. And that could be very unfortunate, having regard to the whole purpose of a CTO and the relationship with Section 3 conditions of compulsory detention. Thirdly, and relatedly,
this brings into play some of the earlier problems that we've had under the Mental Health Act. If the tribunal discharged the CTO, discharged the patient, which meant that the patient was then discharged from compulsion, but the conditions and grounds for a Section 2 or a Section 3 admission existed, well then those sections could be invoked.
You mean the resectioning?
Yes.
Yes, they could be. But thirdly and relatedly, the discharge of a patient into the community ends the authority of the hospital manager. This is the point, to detain under Section 3. This means that the patient is discharged from any form of restriction under the MHA altogether. Now, Ladyship's point is, well, there can be a resectioning, but it's at odds with the whole point of the recall power. The recall power of which is designed to circumvent the need for a resectioning under Section 3.
But the basis on which the tribunal would be discharging him would normally be that there wasn't even a proper ground for having a CTO.
Yes.
I mean, there is a discretionary power, but there wasn't ground for having a CTO. So it would be quite surprising for a tribunal to do that, and yet it still be necessary for the person to be detained in hospital.
Yes, I think that's right. But fourthly, imposition, variation or suspension of any of the conditions of the CTO is vested solely in the responsible clinician. And fifthly, the powers of recall and revocation of the CTO are also vested solely in the responsible clinician. And so what these various points either singly or cumulatively come to is that we say the tribunal doesn't have any power to discharge for illegality of the CTO itself. But even if it did, as I said earlier, the tribunal can only serve one temporal point. So if there's a variation of a condition, that's a problem. And there's no statutory mechanism to resurrect that kind of jurisdiction, whereas the jurisdiction for judicial review, habeas, etc., would remain continuously throughout the period of detention. And as I said, and this is a point I've made, but I make it now, that to permit or compel discharge under the MHA on fundamental rights grounds breaks the link with the recall power. It produces a result that's irreconcilable with that fundamental feature of the statutory framework. There are arguments about mandatory discharge and discretionary discharge raised by my learned friends. First of all, the argument in relation to mandatory discharge proceeds on the basis of an incorrect interpretation of the words appropriate and available medical treatment. And we say that those words have to be understood in their proper context. If the type of treatment required by a patient is simply not available anywhere, as a matter of fact, that's clearly a matter affecting discharge, for the obvious reason that however much the patient may need the treatment, it's simply not available. But suitable treatment that can in fact be offered to the patient and provided to the patient, such as the treatment in this case, is appropriate and available. And we submit that that's what the words mean in their context. It doesn't cease to be appropriate or available treatment merely because it constitutes a deprivation of liberty. The real complaint, we say, that the appellant has here is about the conditions of the CTO rather than the appropriateness or availability of treatment. But even if appropriate treatment was not available in the community, but appropriate treatment was available in hospital, we say that the tribunal Parliament could not have intended that the tribunal should discharge the patient from liability under the MHA altogether. And on discretionary discharge, we set out our arguments at paragraphs 103 to 104 of our 106 of our case. It's true that discretionary discharge can be exercised in exceptional cases. But what does an exceptional case mean? And we respectfully submit that it's the kind of case that we cite at paragraph 106 of our case. It assumes that for the purposes of discretionary discharge, the statutory fulfillment of the CTO has been met. In other words, that even though the patient doesn't meet the criteria for discharge, discharge can occur because of exceptional circumstances that show that the statutory purposes have been fulfilled. So we quote at paragraph 106, in a case known to the author, the tribunal exercised its discretionary power to discharge a detained patient to enable him to join his parents in the USA and to receive treatment for his mental disorder there. That's the example of a discretionary discharge. And we say, therefore, that, see paragraph 113 of our case, that although the interpretative obligation on the court under Section 3 can often result in a straining or even sometimes a distortion of the statutory language, that is not the position with the Mental Health Review Tribunal in this context. And that's why we respectfully submit that the tribunal doesn't have jurisdiction, but in many ways we would welcome a result that held that it did. My ladies and my lords, I've finished unless there are any further questions.
I think not, Mr. Gordon. Thank you very much indeed. Thank you. Ms. Street?
My ladies, my lords, without wishing to sound as though I am complaining, I do wish just to briefly address the evolution of the Welsh Ministers' arguments in the present case. Because we started in the upper tribunal with the position that the Welsh Ministers said they had no policy arguments whatsoever to provide, to the extent that they didn't even want to be joined as a party to the upper tribunal proceedings, and said this is really all a matter for the UK Parliament. And I don't ask you to go to it, but just for the court's note, that's Appendix Part 2, a letter or an application by the Welsh Ministers MS 320 to 321. The proceedings in the upper tribunal having gone the way they did, and the Welsh Ministers having in fact remained a party joined by Mr. Justice Charles, they appealed to the Court of Appeal. And it's right to note that the necessary implication argument, which formed the essential basis of the Court of Appeal's judgment, was an argument identified for the first time by the Welsh Ministers in the course of the hearing in the Court of Appeal. So it hadn't been foreshadowed in the written arguments filed in advance of the Court of Appeal hearing. We then have, of course, the written case filed in the present appeal, with the Court of Appeal arguments being rerun, and then an additional point about Cheshire West, which had, in fairness, been foreshadowed in the Court of Appeal materials. We then have my learned friend's note on Thursday raising a completely new argument. We then have this afternoon yet a further new argument. The argument that ultimately this is a case all about consent is the opposite of what my learned friend's written case says. He says this appeal proceeds on the basis that consent is not a relevant issue in the case. And the statutory provisions upon which my learned friend built his new argument in the course of the afternoon in Part 4A of the Act are not mentioned at all in my learned friend's written note from Thursday of last week. Now, I say I'm not complaining about it, but the fact is we do submit that those shifting arguments belie an inability on the part of the Welsh Ministers really to grapple with and grasp the real issues in the present case. And I do say as a matter of practice and practical reality, the new argument as formulated this afternoon is one obviously we haven't addressed in any of our written submissions because we had no advance notification that it was going to be taken. With that grumble out of the way, can I deal with the substance of some of the points made by my learned friend? He makes the submission that the conditions are legally incapable of creating a deprivation of liberty. Well, it is plain, we say, as a matter of fact, that these conditions did create a deprivation of liberty. And it is the concrete situation, the practical reality, that Strasbourg case after Strasbourg case says lies at the heart of the determination of deprivation of liberty for Article 5 purposes. And the fact is, on the facts of the present case, PJ was effectively required to comply with the regime by virtue of the conditions, which expressly tied themselves to the risk management plans. And when he sought to do something different, when his behaviour was unsettled, things happened, consequences happened, like his leave, unescorted leave, was revoked. He couldn't go out. He was not free to leave. He was under continuous supervision and control. So those conditions did exactly what my learned friend said they couldn't do, which was coerce a patient to comply. And my learned friend's arguments in relation to Part 4A of the Act, in our respectful submission, reinforce rather than undermine our point. He says, well, it would be unlawful to have conditions that are, in any sense, coercive or seeking to override consent because of Part 4A, but those are the very conditions that we had. He proves rather than undermines our case that these were conditions that gave rise to an unlawful deprivation of liberty. It's also right to note, again, as a matter of detail on the facts of the case, PJ was never asked to consent to the conditions. The Section 17A, etc. regime does not import a requirement of consent. At best, on the fact, it could be said that he acquiesced for a period of time, but plainly there came a point at which, both in terms of his behaviour in seeking to stretch and go beyond the boundaries of the conditions, and then in terms of his direct instructions to his solicitor to challenge them on the basis of a deprivation of liberty, an unlawful deprivation of liberty, he clearly did not give any kind of continuing consent, but nothing changed on the ground as far as he was concerned. Can I just pick up a point raised by my Lady Black with my learned friend, and this turns on Section 17B, that's MS 486, Authorities Volume 1, Tab 1. It is clear on the face of Section 17B, subsection 2, that conditions may be specified not simply for the purposes of ensuring that a patient receives medical treatment, but for one of the other objectives identified in Section 17B2, which include the protection of other persons. So conditions can be imposed effectively, a form of preventative detention containment to prevent harm to others. And it is difficult, we respectfully say, to see what how that would fit with my learned friend's submissions about Part 4A of the Mental Health Act. My Lord Kerr raised a question to my learned friend about the need to examine the consequences for a patient if the patient did not comply with the conditions. And again, we have on the facts of the case clear illustration of the kind of consequences: revocation of leave, use of restraint techniques if necessary, they'll be brought back if they behave in the community in a way that's regarded as unacceptable, observations can increase, and recall remains the constant sword of Damocles hanging over the patient's head. And I referred in my earlier submissions, and it's, I think, set out in our supplemental note, to PJ's own perception of the effect of the conditions. In his own terms. My learned friend made a number of fairly sweeping assertions about what responsible clinicians might or might not do on the ground. Responsible clinicians might give CTOs as much rope as they can before exercising the power of recall. Again, those are assertions for which my learned friend referred to no evidential basis. I will just touch on the issue of consent, as my learned friend has sought to make much of it, and leaving aside the specific facts of the present case. We respectfully submit that the answer to the issues raised in the present case cannot turn on the subjective element or the question of consent. It's I can't remember which of the authorities that the phrase comes from, but it's one that the court will no doubt have seen in MM. It's a Hobson's choice, for the most part. Prisoner asked if they want to move from Category A prison to Category D prison is going to say yes. Doesn't mean that they're not deprived of their liberty.
Well, that's what Buzagi was all about.
Yes, my lady, I was just about to mention, but that's exactly what Buzagi was all about. And that was held not to the fact that the individual in Buzagi had asked for house arrest because he didn't want to remain in the particular form of detention he was in, did not mean that the house arrest was not a deprivation of liberty, and because effectively it was an agreement that was with an element of coercion or duress. It couldn't be said to be sufficient to waive what was otherwise an objective deprivation of liberty. And my learned friend made the point that, of course, the consent, even if given at the outset, can be withdrawn. We would respectfully submit that consent can't confer a power to deprive someone of their liberty when one knows that that consent can be, as was the case here, if there was anything that approximated consent in the first place, be withdrawn. Consent can't, we would respectfully suggest, change the fundamental character of a deprivation of liberty into something that's not a deprivation of liberty, save potentially in very narrow and specific circumstances. We would just, I think my Lord Kerr in Cheshire West, I'll just find the reference. It's Authorities Bundle 2, tab 9. MS 914. This was in the context of dealing with absence of objection. The notion that absence of objection can justify what would otherwise amount to a deprivation of liberty is contrary to principle. It's true that a person's consent, provided it's freely and properly given, may serve to defeat a contention that she's been deprived of her liberty. But it involves turning that principle on its head to say the absence of objection will justify what would otherwise be a deprivation of liberty.
That's Lord Neuberger, is it?
So no, that was Lord Kerr, I thought. I may be wrong.
I think it's Lord Neuberger.
I'm sorry, my lord. Your lordship's
You would be deeply
absolutely
offended by
right.
Almost as authoritative.
Well,
look forward
they were
to
concurring
that.
judgments, but my lord is absolutely right. My apologies. I think, in fact, the passage I had in mind from my lord's judgment was paragraph 76 on page 916, where my lord said, whilst there is a subjective element in the exercise of ascertaining whether one's liberty has been restricted, this is to be determined primarily on an objective basis. Restriction or deprivation of liberty is not solely dependent on the reaction or acquiescence of the person whose liberty has been curtailed. That was the passage that I had in mind. And the issue is obviously touched on by the Court of Appeal in the MM part of its judgment, but I'm not going to trespass further on MM because I'm conscious this court's heard argument about it. And then my learned friend then went on to submit that the present context is not what he described a paradigm case of deprivation of liberty. Our short answer to that is, insofar as there is ever a paradigm case, the present case is logically indistinguishable from the facts and the context of those considered in the Cheshire West jurisprudence. Coercion, which my learned friend then also referred to, isn't a prerequisite for there to be a deprivation of liberty. But to the extent that any coercive element is required, it's to be found in the application of the acid test, the continuous supervision and control, and the absence of freedom to leave. And listening to my learned friend's submissions brought to mind the phrase used by Lord Stein in the House of Lords in Bournemouth when he described the idea that the patient was free to leave as something of a fairy tale. And that, with the greatest respect to my learned friend's submissions, is an apt characterisation of the suggestion that the conditions do not bring with them any obligation or requirement or expectation of compliance on the part of the patient. And indeed, that's at odds with the language of the statutory provisions which we refer to and set out in the note that we filed this morning. So that's dealing with my learned friend's first submission. If the court is going to consider further the submissions in relation to Part 4A, and what my learned friend suggests is the effect of that, and indeed to hear what, if anything, the Department of Health has to say, then obviously we would want an opportunity to put those submissions in some form of brief written note for the court.
Of course. I noticed that the Welsh Minister's letter to the upper tribunal applying to come off the record, so to speak.
Yes, Mr. Justice Charles had none of it, though.
Well, maybe so. But what happened to the Secretary of State?
The Secretary of State made the same application. They both applied. Mr. Justice Charles joined them of his own motion. Both applied for disjoinder. Mr. Justice Charles said, well, no, I can't force you to take part in the proceedings, and indeed they didn't take part in the upper tribunal proceedings, but I'm not going to unjoin you as parties. And hence the Welsh Ministers then had as parties the entitlement to bring the appeal before the Court of Appeal.
But the Secretary of State for Health played no further.
Played no part at that stage, no. I may need to check this. I had understood, but I may be wrong, that the original appeal papers from a few months ago had been sent to the Department of Health, but certainly the new argument raised by my learned friend, which would indeed turn the operation of CTOs on their head. My learned friend can admit that that's not been shared with the Department of Health by him, and obviously it hasn't been by us because we've been trying simply to respond to it since Thursday afternoon. So can I then turn to my learned friend's second submission about the Cheshire West principles? He said those principles should be modified. I hope I'm not being discourteous when I say it was unclear to me from his submissions why, he said, the Cheshire West principles should be modified, other than a somewhat oblique reference to context. there is no authority whatsoever for my learned friend's submission that if you're trying to work out what amounts to a deprivation of liberty, it is something other than the Cheshire West approach, which obviously is squarely based upon Strasbourg jurisprudence. My learned friend relied on 2 cases, neither assist. Jolla wasn't even an authority that was concerned with Article 5, and so what was said by way of passing reference over to in a case that was concerned purely with false imprisonment takes the present arguments no further. Austin was, of course, a completely different circumstance in which the kettling that took place was incapable of justification under Article 5. It was in those circumstances that the broader context became relevant. Munjaz, I'm sorry, my learned friend referred on 3, not 2 cases. Munjaz, again, was a very unusual and very different case. An individual already deprived of their liberty in one of the high secure hospitals, I think it was Broadmoor, completely different.
I think it was Ashworth.
Oh, your ladyship's right, it was Ashworth. Completely different from the present case, where you have a patient who, by definition, is not liable to be detained in a hospital at all, because that has been suspended upon the making of the CTO. And then my learned friend's arguments about the context being of the CTO being to enhance liberty, and leaving aside the point I've already made and that my learned friend from Mind has already made, that that's an assumption that can't really be, doesn't have a foundation in fact. My learned friend submissions were really all there, a variation on 2 themes: the relative normality theme, which emerged in the Court of Appeal in Cheshire West, and was soundly rejected by this court when the appeal came before this court. And then the other argument, which again was raised to some extent in the judgments in P and Q, which my Lord Wilson may recall, where I think one of the judgments referred to the exercise of comparing the present situation of P with their previous situation. Again, that wasn't an argument that found any foothold in the Supreme Court. I think my lady asked whether P in Cheshire West had been in hospital. My recollection is, my lady, that he hadn't. Oh. He had previously lived with his mother.
Yes.
But the arguments that were run, by me as it happens in that case, but rejected by my ladyship, were that his liberty was, just as Mr. Gordon argues, being enhanced, because instead of having a very restrictive day-to-day life, he had a life when he was going swimming into the garden centre and so on. That didn't make a shred of difference, this court found. And so there's nothing in that can assist. In relation to Mig and Meg, P and Q.
Well, that was the more controversial decision in the case. But
yes. But there was at least one, there had been, I think, a period in an NHS treatment unit for one of those young ladies. So again, those really are attempts in our respectful submission to get around or to rerun arguments that were rejected by the Supreme Court in Cheshire West. And so we would say in relation to this point, unsupported by any authority, inconsistent with ECHR case law, inconsistent with this court's decision in Cheshire West, and frankly unworkable in practice. My Lord, this was Lord Newberger in Cheshire West, paragraph 60 of his judgment, MS 912, talked about the need for there to be a focused test for deprivation of liberty. But a test which is just, well, it's less restrictive than previous circumstances, is not a focused test. It's not a test capable of universal application. My learned friend fails, for example, to address how much less restrictive. As I don't think I need to say anything further in response to my learned friend's point 4 on necessary implication. My lady correctly summarised the way in which we put our case in that regard. In relation to that issue and the question of necessary implication, we say the court should stand back and look at the language, the logic, the structure of the Act, its purpose and context, and applying that whole line of authority from Sims through to B. Algeria and Morgan Grenfell, we say there is absolutely nothing to suggest that Parliament squarely confronted the question of deprivation of liberty or community detention and accepted it, there is nothing to make clear that was the intention of Parliament, still less anything compellingly clear, which is the phraseology used in one of the authorities. And it's not enough, even if one accepts this is the case, which we don't, that the outcome might be one that's beneficial or in the public good. And that I think, is an observation my Lady Hale made in the Black case, the prisoner smoking case. So I think that leaves me...
Well, you're just about out of time.
I know, my
so
lady.
If you can spend a minute on jurisdiction, if you want.
I will spend a minute. Most of the arguments that we would want to make are in the written case. Yeah. I think just 2 or 3 very brief points. Firstly, we accept that there is a procedure for the obtaining of a CTO and the making of a CTO. Our point is that there are not criteria, there is not a process which focuses on the question of deprivation of liberty. And I'll just give my ladies and my lord the reference. It's the same paragraph in HL that Mr. Gordon took you to, but there's just one specific sentence. So it's HL paragraph 120, MS 1741, where one of the defects was said to be the lack of specific provision requiring a continuing clinical assessment of the persistence of the disorder warranting detention. And that's the issue here. There is nothing in the CTO provisions that provide any kind of criteria, test, touchstone, threshold for deprivation of liberty, and so they cannot be sufficiently clear and accessible. In terms of the authority of the tribunal, my learned friend made the point, well, under the Act, you can only go to the tribunal once in a given period of the duration of the CTO. That's right, although the Secretary of State has under Section 67 the power to refer to the tribunal at any time. But that, in any event, is not a good reason for preventing a patient from at least being able to go that once for each CTO period to the tribunal. I think anything I say about judicial review would probably be simply a repetition of what we have put in the written case. And of course, arguments about Article 8 and proportionality might be capable of being raised through Section 7 proceedings or judicial review, but we're concerned with the Article 5.4 legality of review for the purposes of this submission, and it's in that context that we say judicial review is deficient, and that Section 3 of the HRA, read with Section 72 of the Mental Health Act, clearly permits the tribunal, indeed arguably requires the tribunal, to determine whether there is an unlawful deprivation of liberty, and if so, to bring that to an end. My ladies, my lords, unless I can assist further, those are our submissions.
No, thank you very much indeed, Ms Richards. Thank you to everybody for the novelty of the arguments with which we have been presented in the course of the day, along with some familiar ones as well. We will now go away and try and work out what the answer is and let you know in the usual fashion. Court will now adjourn.